Firearms designed to inflict maximum casualties do not belong in our streets.
Virginia's new gun law goes into effect.
It will be a crime for anyone to buy or sell an assault weapon in Virginia.
Our founding fathers wanted us to be able to protect ourselves, and they specifically said that the Second Amendment shall not be infringed.
This is good public health policy.
There's no advantage to any of this. This is all political.
Well, I think the gun laws that have been proposed in Virginia are a little bit unfair to the people that actually follow the laws.
New laws will affect how you store your firearm.
The assault weapons ban and the public carry ban are obviously unconstitutional.
Another new law will make it a crime for anyone to leave a handgun in a vehicle unattended unless it's out of plain sight in a locked container.
I think they're unconstitutional, and it's very unfortunate. It's just punishing law-abiding citizens. And
3 judges have now reviewed emergency requests to block Virginia's assault weapons ban. 3 times the answer was no. The law takes effect in 11 days. The legal theory most likely to stop it has not worked. Not a single court in this state has issued a pause order. This is a breakdown of what the law does, why the injunctions failed, and what the active legal challenges have left to argue. Virginia's law bans the sale of 2 categories of items starting July 1st. Governor Abigail Spanberger signed it after the General Assembly passed it along party lines. The first category is firearms the law defines as assault firearms. These are semi-automatic centerfire rifles that accept a detachable magazine. They must also have at least one of several listed features. Those features include a pistol grip or a thumbhole stock. A folding or telescoping stock qualifies. So does a grenade launcher mount. The second category is detachable magazines capable of holding more than 10 rounds. Both bans apply to sale only. Possession of items purchased before July 1st is not criminalized. No registration requirement exists, and no surrender requirement is written into the law. The injunction record has been consistent across every court that reviewed an emergency request. The most recent denial came from a Spotsylvania County judge. Former Virginia Attorney General Ken Cuccinelli brought a state constitutional challenge using Virginia's militia clause, that is the provision in Virginia's own constitution. It addresses the right to bear arms in the context of a well-regulated militia. The judge found the argument insufficient for emergency relief. Cuccinelli has signaled the challenge continues up the appellate ladder, but the immediate door closed. The broader constitutional fight is running on 3 simultaneous tracks. The first runs through federal court under New York State Rifle and Pistol Association v. Bruen. That is the 2022 Supreme Court ruling that restructured Second Amendment analysis entirely. Before Bruen, courts used a 2-step interest balancing framework. Legislatures presented public safety evidence. Courts weighed that evidence against the burden on the right. Bruen ended that approach and replaced it with a single question. Is the regulation consistent with the historical tradition of firearm regulation at the time of the founding? The government must produce historical analogs, specific laws from the founding era that regulated firearms in a comparable way. If no comparable historical law exists, the modern regulation fails regardless of its public safety justification. The Second Amendment Foundation is the primary plaintiff on the federal Bruen track. The Cato Institute has separately identified a related opportunity. Local prosecutors and sheriffs may hold independent standing to file their own challenges on this same track. That would give the government 2 simultaneous fronts to defend. The central difficulty for the government under Bruen involves the rifle itself. AR platform rifles are the most widely purchased long guns in the United States. Tens of millions are legally owned. Producing an 18th century historical analog for a categorical ban on that rifle class is hard. Courts applying Bruen have found this burden difficult to meet. The Bruen majority was direct on this point. Interest balancing is gone. A court cannot uphold a gun law because it serves public safety. The historical record either supports the regulation or it does not. There is a separate constitutional theory running alongside the historical tradition argument. District of Columbia v. Heller, the 2008 ruling that established individual Second Amendment protection, holds that firearms in common use for lawful purposes carry a presumption of constitutional protection. AR platform rifles are the most purchased long gun in the country. That common use status creates a secondary argument within the federal challenge. Even if the government produced a credible historical analog under Bruen, banning the most commonly owned rifle in the United States directly conflicts with what Heller established as presumptively protected under the Second Amendment. Plaintiffs in Virginia are running both arguments as parallel tracks within the same federal challenge. courts applying Bruin on assault weapons bans have not reached uniform conclusions. The Fourth Circuit, the federal appeals court with jurisdiction over Virginia, has issued rulings cutting in different directions. Illinois had its assault weapons ban challenged under Bruin. Federal district courts there split on the outcome. Some upheld the law, others struck it down. Those decisions are being appealed now. Maryland's assault weapons law has faced similar fragmented results at the trial court level. Virginia's ban will add to this national picture. Whatever the Fourth Circuit eventually rules will become binding precedent in Virginia, North Carolina, South Carolina, Maryland, and West Virginia simultaneously. What matters for the immediate situation is timing. The outcome of the full Bruin challenge is genuinely uncertain. What is certain is that no court has paused the law before it takes effect. Without a stay, enforcement begins July 1st, while the constitutional question remains open. The second track is the Gun Owners of America and Gun Owners Foundation petition to the Virginia Supreme Court. GOA and GOF took a different procedural route. They petitioned the Virginia Supreme Court directly. Their ask take the constitutional question and rule before July 1st. The Virginia Supreme Court has discretion to accept or decline that petition. If it accepts and grants any form of preliminary relief, the law pauses. If it declines the petition or takes no action before July 1st, the law goes live regardless of what the petition requests. The third track is Cuccinelli's state militia clause argument on appeal. The Virginia Constitution carries an independent provision on the right to bear arms. That provision operates entirely outside the federal Second Amendment framework. A ruling from the Virginia Court of Appeals or the Virginia Supreme Court on that state provision would be binding on Virginia courts independently of any federal ruling. The state and federal tracks run on separate timelines and can produce different outcomes. It is possible for the federal Bruin challenge to succeed while the state militia clause challenge fails, or vice versa. They are legally independent of each other. Federal licensed dealers in Virginia face a layered exposure problem after July 1st. The state layer is direct. Selling a covered firearm or covered magazine after July 1st creates criminal liability under Virginia law. The federal layer works differently but carries more permanent consequences. The Bureau of Alcohol, Tobacco, Firearms, and Explosives monitors licensee compliance with state law. That compliance record is part of its license renewal and revocation review. Documented continued sales of a firearm category banned under state law enter the ATF review file for that license holder. A revoked federal firearms license ends the business entirely. The national stakes around Virginia's outcome are significant. Virginia is one of 12 states that have passed or are advancing assault weapons bans since Bruin. It is among the first to reach this specific legal position. Signed, all injunctions denied, effective date fixed with major constitutional challenges still unresolved. Dozens of county sheriffs and Commonwealth's attorneys across Virginia have publicly stated they will not enforce the ban. That political reality does not change the legal exposure. A Commonwealth's attorney's non-enforcement statement covers exactly one county under one elected official's tenure. The Virginia State Police answer to the governor, not to local sheriffs. State enforcement requires zero local cooperation. An elected prosecutor who refuses enforcement today can be replaced in the next election cycle. Any successor reverses that policy immediately with no grace period for gun owners who relied on the prior statement. If Virginia's ban survives a complete federal Bruin challenge, state legislatures with pending bans will treat that ruling as direct authorization for their own versions. If it is struck down on Bruin grounds, every pending state AWB returns to legal uncertainty at the same time. The Fourth Circuit ruling on Virginia will shape what 12 state legislatures do next. 3 tracks, 3 injunctions denied, 11 days. The law is live on July 1st regardless of where any of these cases stands on that date. The challenges continue. The courts will eventually answer the constitutional questions these cases are built on. None of those answers arrive by July 1st.